Okay, good afternoon everyone and welcome to today's session, which I'll note is being recorded. My name is Beck Nelson. I'm an Associate Professor here at Melbourne Law School and the Director of the Centre, the Melbourne Centre for Law and the Environment. I'd like to start by acknowledging the Wurundjeri people of the Kulin Nation as the traditional owners of this land and pay our collective respects to their elders past, present and emerging. The topic of tonight's panel session, Climate Change and Human Rights, is one that has very clear potential interactions with Indigenous rights and interests, given that First Nations communities are among the first to feel the impacts of climate change, while also often being excluded from policy making. So to start to explore those and other key issues tonight with our most excellent panel, I'll introduce our chair and the powerhouse organiser for this event, Dr. Alice Palmer, who is a Deputy Director of the Melbourne Centre for Law and the Environment. Alice is a senior lecturer at MLS. She teaches several subjects with an environmental focus, including human rights and climate change. Her academic research examines environmental imagery in legal processes, and her early encounter with the intersection between human rights and environmental protection was as an attendee of one of the very first joint meetings between the United Nations Environment Programme and the Office of the High Commissioner for Human Rights. I would have loved to be sitting on your shoulder, Alice. As a then lawyer with Field, a UK-based NGO, she went on to assist a range of not-profit organisations with their work on human rights and the environment. Here at MLS, she has worked with Professor Peel and Rebecca Markey-Towler on a project evaluating the impacts of climate change litigation. So with that, over to you, Alice.
Thank you. Is this working? All good? Thank you so much, Beck. I join you in acknowledging that we are meeting here today on the lands, waters and under the skies of the Wurundjeri people. And I also pay my respects to their elders past and present. It's a great delight that I am joined here with this very esteemed panel. We have Justice Rachel Pepper. I paused because she told me to call her Rachel. I was very proper in addressing her as judge. Rachel joins us as a judge from the Land and Environment Court of New South Wales. We also have Hannah White, who is a senior lawyer with Environmental Justice Australia, and Professor Jacqueline Peel, inaugural director of MCF, Melbourne Climate Futures. And you all have their wonderful biographies as part of the announcement of the event, so I wasn't planning to go through all of that again. But I do just have to say that I've been a long time inspired by Justice Pepper's works in an academic arena. It's very rare for judges to really throw themselves out there in an academic environment, and when they do, it's wonderful. It brings such amazing insights, and so we've been so grateful to have all of the things that you've shared with us. I can hear some feedback on this. And then of course Hannah White, I reached out to Hannah in connection with another matter around EGA's work, and I was very excited when I learned about the new initiative that she's going to be speaking to us about today. And I've also really enjoyed getting to know you and all of the things that you've been doing at EGA. And then of course my wonderful friend and colleague Jacqueline Peel, who I have had the honour of collaborating with on a number of different projects, and of course a renowned global expert on climate change, all things climate change, climate litigation, and not least the specific topic of climate change and human rights that we'll be talking about today. So I appreciate that we have a very mixed audience here today. So my plan was to just give you a little bit of background first, just to sort of provide some context to the very detailed conversation that we're going to have. So the little handout that I provided is just a reference, if you like, for the things that I was going to speak to on those slides. So the first thing I just wanted to cover off was this matter of the different layers of law that we encounter when we're dealing with matters of climate change and human rights. And here in Australia, first and foremost, we have the laws of Aboriginal and Torres Strait Islander peoples. As Beck was saying earlier in the acknowledgement, their laws are extremely important around issues of human rights and climate change, and specifically those understandings, if you like, of caring for country. Then we have what we refer to as the Australian settler laws, and we understand the way in which human rights under those laws operates across different jurisdictions. We have a number of state and territory laws where there is dedicated human rights legislation, but we only have 3 jurisdictions who have that dedicated legislation. That's in the ACT, Victoria and Queensland. And then federally, at the sort of, if you like, the national level, the Commonwealth level, more broadly, we have some very limited rights in our constitution, and we have a number of anti-discrimination laws. Then at the international level, we have a whole host of treaties. These are the agreements that are made between nation states, and one of the ones you'll hear cited often is the International Covenant on Civil and Political Rights. It sometimes goes by the acronym of ICCPR, but there are a number of other treaties that may come up in the conversation as well. In terms of thinking about litigation concerning climate change and human rights in Australia, I just wanted to draw your attention to 2 examples. The one there on the left of the screen is the so-called Waratah coal case brought by a group of litigants going under the name of Youth Verdict. And that was heard in the Queensland Land Court, and it addressed a number of environmental laws, but it also addressed issues under their dedicated human rights legislation. The other example that I have there is what's sometimes referred to as the Torres Strait 8 case, or the Billy case after the last name of the first complainant. And that was a complaint that was taken to a UN human rights body, specifically a treaty body that's created under that ICCPR treaty that I told you about before. And both of those to a case and a complaint, both of them considered the ways in which human rights and climate change intersect, largely from the perspective of the complainants from positive perspective, but that's something that we can go into perhaps a little more in our discussion. A number of the rights, right to life, cultural rights, rights of children and others were the subject of that Waratah coal case. And those very general rights that we see also reflected in the international treaties can be distinguished from a specific right to a healthy environment. And only one of our dedicated acts here in Australia has that right in it, the right to a healthy environment in the Human Rights Act 2004. That was actually introduced by way of an amendment last year. And it mirrors some of the language that's come out of a number of resolutions of international bodies that have also acknowledged the existence of that right, that specific right to a healthy environment. All of those laws about human rights we can contrast with federal environmental laws and all of the state and territory laws that operate around environmental issues. It's a huge matrix, it's very complex, and I won't even begin to try and explain it to you all now. But again, just to make sure everyone's on top of this idea, the main law that we see relevant at the federal level is the Environment Protection and Biodiversity Conservation Act, often known as the EPBC Act. And it gives effect to a select few international environmental laws. And the extent to which it covers off climate change, there's no express mention there, so it's the subject of much debate, both amongst policy circles, but also before the courts. It is subject to a regular review, and the last review in 2020 by Professor Graham Samuel as the chair of that review made recommendations about climate change that were very limited. They weren't as ambitious as some of the submissions that went to that review had hoped for, but there were some limited recommendations there. And the government's response to that review, the Nature Positive Plan, did anticipate some very minor matters concerning climate change. But as many of you might be aware, a suite of laws that were meant to come before Parliament to address many of the issues set out in that nature positive plan were put to one side immediately before the recent federal election. So it remains to be seen at this point what we will be seeing in terms of the response to that review, in terms of the detail. So that just really is what I like to call the whistle-stop tour of these laws. It's really just intended just to help give you that framework of issues that we'll now talk about in much more detail with our panellists. You'll see on the handout that I have given you a number of additional resources if any of you would like to go to those for further information. But for now, I shall stop there, and I might even blank our screen for the moment, because I want to, if that's going to work or not. No, okay. I will just go, I'm going to Hannah's presentation, but I'm actually going to ask Justice Pepper to kick us off. The idea is that we will have about sort of up to about 10 minutes of reflection from each of the panellists. I will then perhaps prompt them with a few further questions, and then we will open it to the audience. I'm very conscious of wanting to give you all plenty of time for questions. So if I find that we've reached time when you all need to be speaking, I won't ask my questions, and I'll move over to all of you. Justice Pepper, over to you.
Thank you very much. And yes, you're right, it is Rachel. I'd like to also acknowledge the Wurundjeri people of the Kulin Nation and pay my respects to elders past and present. I recognise that sovereignty was never ceded, and that it always was and it always will be Aboriginal land. Well, I want to, I guess, test the limits or the utility of climate change litigation. I know much is made of it, and I guess I don't want to be overly negative. That's not the aim of my remarks, but I just want to, I guess, give a bit of a reality check on how far climate change litigation can actually be taken. Now, we know that climate change litigation has increased exponentially in the last couple of decades. There are literally now thousands of climate change litigations in many countries across the world. In fact, there's almost no country now that doesn't have some type of climate litigation law that can be actioned or dealt with in some way in the courts. But we also know that governments and corporations continue to engage in high-emitting activities. We have passed 1.5 degrees. We are on track. I think it's, if we stop at 2, we'll be very lucky, but we're really on track for 3, which is catastrophic. So what has happened? I think this increase in climate change litigation has been a natural response to the fact that people wish to do something. They want action, and so they have filled the sort of the government executive void by taking matters to the courts. That's entirely understandable and legitimate. Now, there are sort of 3 groups of climate change litigation, which I'll come back to, but I'll just, sometimes they're talked about in terms of waves. And they're waves because they sort of started to be popular more or less in this order, but they're now all happening all at once. So we've had, the first wave was sort of challenges to executive action, things like judicial review, and tortious actions, so breaches of duties of care. There's also this thing called public trust doctrine, but that's sort of became a fashionable in the United States. It certainly has never been picked up here, although there's a case called Upper Mukai by the chief judge of my court that sort of tantalisingly said, well, maybe it exists in Australia, but we'll leave that for another day, and it's never been touched. So just really focus on sort of, challenges to executive action and torts in the first wave. There's then infringement of constitutional rights and human rights, breaches of those types of rights, breaches of my, a right to a healthy environment or a right to life. And then finally, on what we've seen, I think more recently coming through the courts, is application of corporate and consumer law. So breaches of directors' duties, and probably the best example of some of this litigation is the greenwashing cases. And they have been very successful. Federal court now is handing down penalties in the tens of millions of dollars. And it's had real regulatory, it's resulted in real regulatory change. APRA and ASIC are both pursuing companies quite rigorously in relation to greenwashing claims, which is good. But again, what effect is this actually having on driving down emissions and basically resulting in positive environmental outcomes? That's probably a study for very clever academics to do some empirical work later on down the track. But I'm not seeing a lot of it come through. Now, you will have heard of some of these cases like the Sharma litigation in the federal court, where at first instance, Justice Bromberg said, yes, there was a duty of care that was owed, but of course that was then reversed on appeal. And these tend to be these sort of large headline-grabbing pieces of litigation, which are great. They have positives, which I'm going to come to. But I just wanted to remind everybody that often the headline-grabbing cases tend to mean that the more prosaic, localized climate change litigation is overlooked. A lot of climate change litigation occurs at the local level, at the state level, under things like, in my court, the Environment Planning and Assessment Act, where you might have a challenge to a council decision to rezone a piece of land from what was publicly green space into something that's now going to be used for housing, for example. Now, that's all sort of a species of climate change litigation. It's there to promote better environmental outcomes in order to mitigate climate change adversity. So just remember that, or rather bear that in mind. Well, look, there are undoubtedly positives to climate change litigation. You have increased publicity. That is a good thing. And that means that you raise the consciousness of climate change issues in the public eye. And this does have a very real knock-on and flow-on effect to political decision-making and government policy. Undoubtedly it does. And that, in turn, means we get more government policy, we get better, hopefully improved policy, we get more legislation as well. Certainly, for example, in judicial review, if governments know that their decision-making is going to be subject to judicial review challenge, then it tends to be a little bit more transparent, it tends to be a little bit more rigorous as well. That is a good thing. It has the increased publicity, I think, ended up having a normative effect as well, both on players, both on the actors and those who consume it, and on the public, in the public sphere. It causes and advances in the law. Even though Sharma, on appeal, lost, and the court found that there was no duty when you had regard to the specific words of the EPBC Act. Nevertheless, the Chief Justice Alsop, was careful to say effectively, well, not now with this legislation, but not never. We're not shutting the door on the finding of a duty of care in the way that it was argued. You can get useful information. You can get useful information from companies, for example, through strategic commercial climate change litigation, through discovery actions, through subpoenas and so on, which can often be quite, down the track, can be quite embarrassing. It can cause, and does cause, private actors to change because of fear of reputational harm. It can cause corporate behavior changes. There can even be a real financial risk to corporate actors or individual actors. Their insurance premiums can go up, for example, even though they may be successful with the litigation. Nevertheless, it's a cost, it's a risk, it's a financial risk, and that can cause behavioral change. Factual findings can be made. If you look at the factual findings that were made at first instance in Sharma, they were really quite fantastic. And the judge there went through in some detail to show what would happen and the devastating impact climate change would have on future generations. And that those were findings that were not challenged and therefore not overturned on appeal. They exist. Likewise, you can have there's precedential value in climate change litigation. So the findings of law can then be used in later litigation, particularly where you've got statutes of sort of much more domestically universal application. So even failures can have positives and can raise public awareness. Cases such as Sharma, for example. There was a case in the United States, Plan B Earth, which is a 2021 case, which failed in the Court of Appeal, but basically due to interest and attention from the press, the United Kingdom Prime Minister at the time, Theresa May, revisited targets that were made under the Climate Change Act and adjusted them down to net zero. She didn't have to, but it was the publicity that was generated from that case, albeit that the applicants didn't win, that caused her to revisit those targets, which I thought was quite interesting. And so there are certainly positives, and it certainly is, I think, a very legitimate avenue to be pursued. But there are also, I think, problems and disadvantages that have to be borne in mind before we rush down the climate change litigation path. And I want to go back and talk about those three waves of litigation, of climate change litigation, to illustrate the point. So, for example, with the first wave, with judicial review, now we know that even to get through the front door of the court, you have to demonstrate in some jurisdictions standing. So there are issues of standing. There can be issues of justiciability. Again, if you recall the words of the Chief Justice in Sharma, although the issue of justiciability didn't directly arise there, he nevertheless said, look, this is really ultimately a policy question that is best left for the government of the day. There's the cost. Litigation is expensive. There are financial costs. There are emotional costs. And even though some jurisdictions have got some nifty cost rules, like mine, to protect parties, whether it's a case where there's a case of true public interest litigation, nevertheless, you still have to fund that initial challenge. There are remedies. Judicial review just means that, well, the decision maker remakes the decision if indeed you're successful in your judicial review application. We've seen that time and time again when it's come to judicial review of environmental action. The minister fails, and the minister just simply remakes the decision again, correctly this time, and the coal mine is approved. Tort, well, you've got a big issue there of causation. Now we have climate attribution science, which is basically facilitating and easing some of the issues that arise with causation, but it is still a live issue in the courts. The second wave, constitutional rights. Well, there's nothing in our constitution that talks about the environment or indeed even human rights, other than a implied right of political communication. We certainly see a much greater use of climate change litigation based on constitutional rights utilized in the global south. I can give you some examples. You've got the right to, for example, right to life in Nepal, India, Pakistan, Netherlands, has all been construed by courts there to include, this is all constitutional based, I should say, to include a right to a healthy environment. But, you know, if you compare the environmental outcomes of countries like India and Bangladesh, where you have an entrenched right to life, which has been construed as including a right to healthy environment, versus the environmental protections we have in Australia or the UK, which doesn't even have a written constitution, you can see that just because you've got constitutionally enshrined rights, that doesn't necessarily mean that you're going to get better environmental outcomes. Same with human rights as well. Most human rights legislation doesn't contain any right to a healthy environment. It contains a right to life, and I think it's probably, I think we're inching, probably not even inching, I think we're getting much closer to a court now saying a right to life must include a right to a healthy environment. You know, what is a right to life if it doesn't include drinkable water, breathable air, shelter, and so on? But we're not there yet. Corporate consumer laws, the sort of what I call follow the money, climate change litigation, again, that can sometimes be absorbed by large corporate emitters as just the cost of doing business. That can and does happen. And even if there's a change in sort of regulatory enforcement or corporate behaviour, again, we're seeing this in the greenwashing space, it doesn't necessarily lead to improved environmental outcomes. In fact, in 2022, 54% only of climate change litigation resulted in a win for the applicant, which when you consider the cost, I don't think is a great statistic. And even when you have a win, it may not result, as I said, in longer-term change, beneficial change. The agenda litigation is a good example of that. You've seen no real meaningful, tangible reduction in greenhouse gases in Holland, and indeed they just offshored some of those greenhouse gas emissions to the UK, who saw theirs increase as a consequence. And of course, governments can always change the law. The Rocky Hill decision, which was a decision by the Chief Judge of my court, a very groundbreaking decision, prompted the New South Wales Parliament to simply change the mining state environmental planning policy to really to mean that very limited weight was given to the protection of the environment. Much more weight had to be given to economic factors, and it really did change. Under the changes to that SEP, Rocky Hill would have probably never have arisen. So these are all things I think that you have to sort of bear in mind. So what's the solution? In my view, it's legislation. We need to have much more robust, enforceable legislation at the national and state level. We need to have clearly identifiable objective criteria that is amenable to judicial determination. Overwhelmingly, I think we need this because as a judge, I'm unelected. And I need to maintain my agency as an independent arbiter. I operate within a constitutional framework. I'm not permitted to rewrite laws that I don't like. There's only so much I can do when it comes to statutory interpretation. I can't basically interpret laws that is clearly contrary to Parliament's intention when they pass them. That is simply not allowed. A good example of that is the bushfire survivors case, which I actually think is probably one of the most important climate change litigation cases that's happened in Australia. Again, that was a case from my court by the Chief Judge. There, he construed the relevant legislation to say, well, the EPA has a duty to promulgate climate change policy. They're not carrying out that duty, and he ordered them to do so. So that was permitted under the legislation, but what wasn't permitted was for him to then dictate the content of that policy. That had to be left to the EPA. Now, as it stands, we had a change of government. Labor came in, and they directed that there to be no appeal, and we then got some really great policy coming out of the EPA in respect of climate change. But they could have just basically done very little and complied with the court's order. Even in Sharma, the court said, look, it would be an impermissible reading of the EPBC Act for us to find a duty of care arising from the particular provisions that were in question in that piece of litigation. Here you've got an act that has no mention of climate change, no mention of emissions, no mention of targets. We just can't construe this legislation. It's indeterminate and incoherent with respect to climate change, and it would be impermissible for us to construe that legislation in that way. And that's what happens when you have a system which is based on the rule of law. That's entirely legitimate. So we need comprehensive, I think, climate change laws enacted both at the federal level, at the state level, that allow people like me and my court to actually do something with those laws. Otherwise, as I said, climate change litigation, I think, will only take you so far. So for me, in summary, the bottom line is litigation can't be a substitute for legislation. The two are complementary. You have to have both before you can have meaningful climate change outcomes. Thank you.
Excellent. Thank you very much. That was very comprehensive
overview, and as we were discussing before about that sort of potential of the negative side of some of these initiatives, and you were sort of preferring to describe them as a more practical perspective. But I can imagine, Hannah, that some of those problems and hurdles that have just been outlined are behind what motivated Environmental Justice Australia to take on this particular initiative that you're going to share with us.
Yes, that's right. I might pop up to the podium. All right, good afternoon, everybody. My name is Hannah White. I'm a lawyer in the climate team at Environmental Justice Australia. Before I get started, I'd like to acknowledge the Wurundjeri people, the rightful owners of this country, and their ongoing connections to the lands, waters and skies. And I pay respect to elders past, present, and to all First Nations people here today. I'd also like to acknowledge the remarkable international leadership that First Nations people and people from the Pacific have taken on to call for climate action and their fight for climate justice. Climate change is not a problem that First Nations people have created, but they are leading the way and calling for climate action and often leading climate litigation. There can be no climate justice without First Nations justice, and I think that's just something really important to remember, especially in this space around climate change litigation. So today I'm going to be speaking to you all about a really important piece of work that we've just finished up at EJA, or just started in some ways. So for those of you that don't know, Environmental Justice Australia is a public interest environmental legal organisation, and through our legal work we aim to support and empower people and communities to hold those in power accountable for the harms caused by the climate crisis and also harm to the environment. I've been working at Environmental Justice Australia for about 2 years now, and then throughout that time I've been lucky to predominantly work exclusively on climate change litigation. So I'm a believer in climate change litigation, and I think it has a lot of power. So yes, I'll tell you a little bit more about the work that I've been doing. So lately, my focus has been on using international legal avenues to address the human rights impacts that climate change is causing in Australia and hold those responsible to account. So in this case, it was the Australian government. In particular, the work that my colleagues and I have been doing is to support an extraordinary group of young people to bring a complaint to the United Nations Special Rapporteur on climate change. For those of you that might not be familiar, the UN Special Rapporteur on Climate Change is an independent human rights expert appointed by the Human Rights Council, and her job is essentially to ensure the promotion and protection of human rights in the context of climate change. Her job is to investigate, report and advocate for the protection of human rights, and critically, she has the power to receive complaints from individuals and communities and raise those rights violations directly with governments and ask them, or in our case, urge them to act and prevent the human rights violations in question. In April, my colleagues and I submitted a complaint to the Special Rapporteur on behalf of 9 young Australians up here who call themselves Generation Justice. These young people come from communities all across Australia, and they are already at the front lines of the climate crisis. They are children, they're First Nations people, they're people of colour, they're disabled people, and they're from rural and remote regions of Australia. The story they've shared as part of this complaint are deeply personal and offer a glimpse of what it's like to be growing up in what the UN calls an era of global boiling. It details their experiences living through heat waves, bushfires, floods, as well as their increasing anxiety of what it's like to not know what their future might look like in the face of government inaction. For Connor, who's one of our complainants, Connor, who is a Larrakia man, climate change is destroying his culture through shifts in seasonal patterns which have threatened the way he practices his culture. And for Johansa, who is growing up close by to Western Sydney, extreme heat waves have impacted her health. We're having a time here. Yeah. There we go. That's Johansa. So she's 16 in Year 12 and dealing with crippling headaches due to extreme heat waves. So what does our complaint to the Special Rapporteur say? on behalf of these 9 young people. In their complaint, each of them share their personal stories and explain to the Special Rapporteur that they're already experiencing serious and life-altering harms due to climate change that is threatening their rights to life, their rights as children, their rights to culture and to a healthy environment. With these stories, they ask the Special Rapporteur to intervene on their behalf and urge the Australian Government to take action to prevent these climate harms. Their complaint then goes on to explain to the Special Rapporteur why her intervention is necessary. It alleges that the Australian Government is failing to protect their human rights by not taking sufficiently ambitious action when it comes to climate change. In support of this allegation, the complaint sets out extensive evidence which we say establishes that Australia has engaged in a course of conduct that is in direct contravention of its obligations under international human rights law and under international climate law. In summary, we say that there were 3 distinct types of conduct that the Australian Government has engaged in which constitute a violation of the complainant's human rights. The first is that Australia has failed to set a 2030 nationally determined contribution, which is a requirement under the Paris Agreement, which aligns with what science tells us is necessary to avoid catastrophic climate harm. For reference, and for those of you that aren't an NDC nerd like I am, Australia has one of the least ambitious targets amongst developed countries and amongst the richest nations. As it currently stands, reaching Australia's 2030 target would see global warming of more than 2 degrees and more likely 3 degrees, which is a far cry from the 1.5 that the Paris Agreement set out to achieve back in 2016. The second category of conduct that we allege that the Australian Government has engaged in is its ongoing promotion, subsidisation and expansion of its fossil fuel industry. The evidence that we use to support that argument is that the Australian Government since 2022 has approved 10 major new coal mines or expansions. It's spent more than $14.5 billion in subsidies propping up the fossil fuel industry. And importantly, this complaint points out that the Australian Government, despite being one of the world's largest exporters of coal and gas, has no legislative framework to account for or reduce its disproportionately higher exported emissions. The final category of conduct that we refer to in the complaint is that Australia has failed to ensure that people and communities who are impacted by climate change have access to effective remedies at a domestic level which allow them to actually seek redress for the climate harms they're experiencing. And it's this third category that, in particular, the lack of effective domestic remedies, which really served as the catalyst for these 9 young people to make the choice to make a complaint to the United Nations. Unlike other countries, and as Justice Pepper has referenced, Australia has no National Human Rights Act. There are no constitutional protections for human rights under the Constitution, and there's no legal duty of care requiring the government to consider the impact of climate change on young people, or anybody for that matter, in its decision making. With no meaningful domestic legal pathways available to remedy their climate harms, each of our clients chose to turn to the Special Rapporteur and ask her to take action. They've asked the Special Rapporteur to write to the Australian Government and urge them to immediately stop engaging in the conduct that I've told you about today. They've asked them to end the continuation of its expansion of the fossil fuel industry, to rapidly phase out the production of fossil fuels, to cease the subsidisation, the billions of dollars that the Australian Government is paying to the fossil fuel industry, and importantly, set NDC targets that are aligned with the best available science. In receiving and acting on a complaint like this, the Special Rapporteur plays a really important and integral role for our clients. Not only in writing to the Australian Government and urging them to act, but she can also give this complaint and their stories a platform and an opportunity for them to have the political weight they need to talk about what they're actually experiencing. This isn't numbers and 1.5 degrees and technical stuff. This is about their lives and what's happening to them now, and they're hopeful that this will give them the platform to actually talk about that. And while we acknowledge that international human rights mechanisms can be toothless, they can be really slow. There's a lot of bureaucracy. Like, if you think the Australian Government has bureaucracy, I expect the United Nations has much more. These sorts of mechanisms are often not enforceable at a state level. But from our perspective, international legal mechanisms still matter, and they have a really important role to play, especially in the context of climate change. International complaints like this won't change the laws in Australia overnight, and they're no substitute for strong domestic legal reform. But they do help reframe climate change as a human rights issue, and they help build pressure for the reform and expose the failures of the current domestic system. At its core, the complaint that our clients have made to the Special Rapporteur seeks to ensure that young people affected by climate change have a pathway to seek justice for the harms that they're experiencing and take steps to hold the government accountable for their failures in acting on the climate crisis. It shouldn't have to be the case that children and young people have to feel compelled to prepare a complaint, engage lawyers, and go all the way to the United Nations to have their voices heard and protect their rights for a safe future. But until we see significant change in our domestic legal systems, the use of international legal mechanisms is one of the few avenues that Australians can use to advocate for themselves and advocate for their rights in the context of climate change. If you'd like to read a little bit more about the complaint, I've linked up the website there, which is generationjustice.org.au, or you can always come and have a chat with me after. I'm really happy to answer any questions about it, but that's that. Thank you.
Thank you so much. Okay, so we will now move to our final set of reflections from Professor Jackie Peel, and hopefully we can have an opportunity to sort of connect some of the dots between the different presentations before we all speak as a group.
Thanks, Alice. And that's exactly what I'll try and do with this intervention, and keep it pretty short so that there is an opportunity for questions. So I think you've heard both sides of the perspectives on climate litigation. So the judicial perspective that Rachel was presenting really reflects on the fact of hearing these cases, and sometimes the frustrations with the way that they're brought and the frustrations with what they can actually deliver. But Hannah's perspective, from a litigant's perspective and from a practitioner's perspective, shows why we're still having a lot of climate litigation, because there's a feeling that there's not other avenues to pursue, and that those who are most affected feel that this is a useful way, whatever the result may be in a sort of courtroom or litigation setting, to have their voices heard. So that's the two different perspectives. I thought from an academic point of view, since I'm designated as the academic for this, I'd just try and put a bigger picture framing around that. And one of the things that it made me immediately think of was this article that I wrote with a colleague from the US in 2017, and it was called A Right's Turn in Climate Change Litigation. And what we were writing about was we were starting at that stage to see human rights arguments appearing in climate disputes and in cases taken before courts, and that there were these sorts of arguments going on around the world, not particularly in Australia at that time, but in a lot of other countries. And we're interested in whether this signalled some kind of turn or trend towards human rights arguments being used by litigators, and potentially being judges being more receptive to this kind of argument. And we're interested about what the implications of that might be, whether it would make climate litigation more effective, what sort of new arguments that might bring, whether it might deliver different kinds of outcomes for those trying to use these avenues. And I was writing from an Australian perspective particularly, my co-author was from the US, so we were kind of interested in whether this was something that might take off in our own countries. And the reason why I bring up this article, it's open access, so if you just search Right's Turn, you can find it, is because I think the conclusions that we reached, even though we reached them in 2017, largely still hold true today. And you've heard about some of those sorts of things in both the presentations from Rachel and from Hannah, but I'll just summarise them. One is that we said in conclusion that we thought that there was a rights turn occurring and that it would accelerate. And that's sort of what we've seen, that there's been an increasing number of these cases and greater use of human rights arguments. So there's definitely something going on there. We've got more human rights-based cases since 2017 than the handful that we saw at the time. But the key thing that we tried to emphasise was that this is not something that's going to be suitable in all countries and in all jurisdictions. It's going to be a kind of selective or mosaic pattern, and it's very dependent on what legal frameworks and what social frameworks exist in different countries. We've heard a lot about the sort of legal frameworks that we have and whether they'll sort of support human rights arguments. In Australia, this has been an uphill battle because we don't have that legal infrastructure that really gives you a hook for human rights arguments in climate cases. We've got some state legislation, we've got some very creative lawyers who've been able to use that, but largely we don't have a National Bill of Rights. We don't have strong human rights protections. So there's not the same kind of legal infrastructure that we can build on for climate litigation on human rights in Australia. And then there are complexities with human rights arguments. One of them is trying to link the horrible things that are happening to particular people, heat stress from extreme heat waves causing anxiety or causing health effects for young people. Can we link that human rights violation to the activities of some actor that has to be held accountable, usually a government? Does the fact that Australia's dragged its heels on the 2035 target for emissions reduction, or is still exporting lots of emissions, or is opening new coal mines, does that make it, as one country amongst 190 odd countries, particularly responsible for those human rights violations? So in Australia, what we've tended to see is a very limited use of human rights arguments, some state avenues, and as Hannah was referring to, a reach out of our own system to international, to sort of global systems to try and get action here in Australia. Where we are seeing growth in human rights climate litigation is in those countries and in those jurisdictions that have supportive preconditions, and there's three sort of key ones there. One is good access to justice. If you don't have courts, if you don't have rights to access courts, you don't tend to see these cases. Civil society, a strong civil society, again, if you don't have advocates and access to lawyers and also just civil society who are organising around these issues, you also don't see them. And finally, which is something Rachel mentioned, that legal infrastructure. If you've got constitutional rights, human rights embedded in that legal infrastructure, you're more likely to see these cases. And that's the same in the international sphere where we have some of that, and so you're able to use those avenues. Just one final thing, I agree with both Hannah and Rachel that when we're looking at litigation, sometimes it's not the success in the courtroom that's the most important thing. There are a range of other things that litigation might deliver without necessarily being a win. But one of the things that it can be most hard to show is that litigation equals reductions in emissions. A lot of the stuff that we see out of this litigation is actually about providing platforms for people to tell stories, to influence policy, to influence the public debate, to shift corporate behaviour rather than to bring about the reduction in emissions that we know is necessary for achieving those temperature goals. That doesn't mean that it's not a useful exercise, in my opinion, but it does mean that it can't be the only tool that we rely on to generate the change that's needed. So I'll stop there.
So that brings us to the end of the discussion, and it now falls to me to thank everyone. I want to obviously thank all of you. You've all come here on a late afternoon on the hump day that is Wednesday and been so generous with your time and the questions that you've had for all of us. So thank you so much for being here. And I also want to thank Claire and the rest of the team from the Office for Research for all the work that they've done in organising the event and their support to the Melbourne Centre for Law and the Environment. We really rely on the amazing work that they all do to bring the food and all of us here together in comfort. So thank you very much also to you and of course to Beck, the Director of MCLE. And last but not least, of course, to our wonderful panel. As I said, I really feel such pleasure and privilege to be here amongst such fine minds. And I'm also very grateful to the three of you for so generously sharing all of your insights with all of us. We've had the judge, the advocate and the academic, and I think we've all got some amazing perspectives from them on the matter of litigating human rights and climate change in Australia. So thank you everyone. If you could join me in thanking our speakers.